Good evening, good afternoon, good night. Hope everybody's well. Like, comment, subscribe, say hello, ask questions, send to your friends, but most importantly, of course, share with your canines. I love the canines. And before I get started, again, not legal advice, don't rely upon anything. And also, this is not financial advice. So, to the extent this one strays into anything that might be construed as that, it is not intended as such. So, um, in my opinion, before we go on, geology rocks, but geography is where it's at. Anyway, tonight I was going to discuss uh, three or four quick things. And when I say quick things, of course, it's not going to be quick. Sorrento Therapeutics, finger motion, Gary Gensler, and Richard Hofman's arbitration. So quickly, I was listening to Daniel Borders' uh, a live stream or spaces that he was on today, and they were talking about ways to resolve naked shorts and how you would actually pay them out. And I think they were referring to like a Dole Pineapple example where you would figure out some average cost of the shares. And the point I wanted to add was in Sorrento Therapeutics, which was that Texas case recently, they were able to set up a committee favorable to the company and the shareholders to evaluate the share price for the naked shorts to close. And that was done confidentiality, but it was a much more favorable setup. So if Daniel Borders is listening out there, then here you go. That's another alternative way of dealing with it. Uh, Two, finger motion. So finger motion is a stock along with GTII, again, not financial advice. It seems to be and it fits the same kind of criteria, naked shorting, been driven down, bunch of scumbags who are shorting, you know the drill. But in this case, it appears that uh, they may have the upper hand over the shorts. And it also appears that a lot of people that were involved in other plays where naked shorts were implicated and people got screwed have combined and associated, not directly, of course, but associated in being interested in this particular play. And that particular play, finger motion, FNGR, is connected for some reason to GTII. So people think that if one goes, the other will go. And right now, attention's focused on finger motion, which is a company that's based in large part in Malaysia. It's in telecommunications business in China. I think it has an office in New York also. It has moved quite substantially. There's a lot of interest and increased volume. And again, it seems to have, for whatever reason, become the play to represent all of the retail shareholders that were screwed in the naked shorting of other securities. So there are a lot of common people involved, and who knows what's going to happen to it. But yesterday and last night, interesting enough, there was a filing. I think it was an S3 filing as to an offering, but through a lender called Univest, and Univest is known to be a short killer. In essence, what they do is they finance the purchase of stock, but at the price, at not a discount, and at market. And they usually don't get involved at first. And it serves as a means often that results in elevated prices. If you look at the history of Univest, a lot of the companies that they have been associated with have made dramatic moves and risen substantially. So they just got involved. The security seems to be running well. Who knows what's going to happen? But a lot of people are watching it, and GTII, a lot of those people also expect to move afterwards. So I'm certainly not telling you to buy it or anything like that, but just for fun, why don't you just watch the symbols, watch to see what they do, and see how these particular shorted vehicles, what they're doing. And again, the symbols are FNGR and GTII, and there seems to be a lot of interest in both. So I would urge you to take a look at those. I think I did a live stream on Sunday night, and I referenced finger motion there at that time, and since then it's made a significant move up even from that time. So that's that, and that's certainly not any kind of recommendation to do anything. Third, I saw Gary Gensler's testimony before Senator or from Senator Cabo, I believe, about MMTLP. I was impressed that the senator asked those questions. I was impressed by whoever drafted those questions. I appreciated that. And I thought about it. And as I was doing this video, I thought I started to write questions. I really wasn't planning on it, but I thought to myself, if I got in the situation where I could ask Mr. Gensler questions, what would I ask him? You know, some of the things I would ask him. And I was thinking about, I love dogs, and I have two dogs, both Ridgebacks, and my guy is Dante, and he loves me, and I love him. And but he's not, not necessarily the sharpest guy or attentive. We also have Agatha or Aggie Pie, who's a puppy, but this one's directed at Dante. And Dante, he and I are outside, and sometimes, even though I love him, and I don't mean this with any uh, malicious intent, but sometimes when he's not paying attention, I quietly call out to him and I say, "Dickhead, hey, over here," just to get his attention. And I kind of laugh when I say that. Nobody else can hear me saying that. And so I was thinking about that, and then I was thinking about Gensler, and if I had him and a chance to speak to him. And by the way, Congress at this point in time certainly can issue a subpoena to the SEC to get documents, transactional records of MMTLP, etc. There certainly would be a fight, probably, but they certainly probably also would be able to get some level of records. So I would suggest that they do that. But anyway, getting to my conversation with Mr. Gensler. So Gensler's not Dante, so I don't love Gensler. So we get into a room and we're having lunch, and I say, "Hey, dickhead," referring to Mr. Gensler, "I heard you just say that you could not comment about whether there was an investigation into MMTLP. I heard that. But I know in response to FOIA requests that your office specifically asserts the investigation privilege, stating that there is an ongoing investigation into MMTLP. So why did you say that there wasn't? What was your thinking at the time? Also, do you mind if I call you DH for short? Now, each time you testify before Congress, you make a point that you are testifying personally. You say that because you don't know what is occurring within your own agency. I would think that if you were director or CEO, you should know what's going on under your nose. Do you disagree with that? Can you explain for me why, as director, you do not feel comfortable with your state of knowledge to testify on behalf of the SEC? I was a little disturbed when upon questioning, you briefly feigned a lack of knowledge as to the existence of MMTLP. That purported lack of recollection of the MMTLP situation was quickly eviscerated when you unilaterally volunteered the correct December 2022 date for the U3 halt. Why did you feign or pretend you did not know about MMTLP? Is it because you're embarrassed over the handling of MMTLP by the SEC or FINRA? By the way, I know that you referred in your testimony about FINRA's rules and those being separate from the SEC's rules. Wasn't that correct? Am I correct in that hearing that? But the SEC has supervisory responsibilities as designated by Congress over FINRA. Isn't that correct? Right? So you know what FINRA is supposed to do, correct? And do you know everything that FINRA does? I mean, you don't know everything, but you know the major stuff, right? Because that's your responsibility. It's the responsibility of SEC. So if something major is happening at FINRA, the SEC is responsible for knowing about the major stuff. And your general counsel, you have general counsel, correct? Your general counsel is one of the senior people at the SEC, correct? And that general counsel reports directly to you, correct? And they report to you about major events impacting the SEC or potentially FINRA. Isn't that true? And it's their job to keep you informed about major events impacting the legal status of either the SEC or FINRA. Isn't that correct also? And as you knew about the December U3 halt per your own testimony, and since your general counsel reports directly to you about major events, you must have been aware in that same December time period of the Mmtlp fiasco in light of the communications between FINRA and the SEC and with your general counsel directly. Isn't that correct? Were you copied on those particular emails? Let me show you the emails per the FOIA reply and ask you, do you remember seeing those after they were drafted? And I would continue on, by the way, but I would take that path and not be super friendly. And that was, by the way, that was 5 minutes. I sat down. Those were like just things that popped into my head that I would ask as follow-up questions, but I could ask a lot more. But I thought his testimony was not different than what I expected, not meaningful. It just puts the burden on Congress to take the next step forward. And Mr. Capo seems like he's certainly on board. So I, again, appreciated his involvement. And we'll go from there. Last but not least, the Richard Hofman arbitration today received a notice on FINRA letterhead, of course. So my objection to having the third arbiter stricken was denied on some nonsensical basis. I had filed a prior objection. I will file a new objection for the record based on just to protect the record in case of the outcome doesn't go as I would like, but I want to protect the record in case of appeal and to establish what's going on. And again, as I said, on my Fidelity arbitration, I will keep you apprised of every significant event that came today. I will be filing another request for discovery, and as I said, I'll be filing an objection to the denial of my objection today. And I will keep you apprised of all that. Hope everybody's well. To everybody falling finger in GTII tomorrow, eat your carrots, watch out. It could be an exciting day. Everybody else, be well, take care, have a great day.